I'll go get it. Okay. You want Tracy?
Yes, you can. Yeah. Hey, y'all ready? Wanna do this? All right, everyone. I appreciate everybody being here for our Civil Justice Committee this week. Madam Clerk, if you go ahead and take the roll.
Representatives Beck, Bricken, Bolso, Capley, Eldridge, Gant, Garrett, Grills, Harris, Lamberth, Littleton, Parkinson, Powell, Russell, Stevens, Todd, Vice Chairman Jernigan, Chairman Farmer. Mr. Chairman, you have a quorum.
Yeah, thank you for that. Members, do we have anybody that would like any recognitions, announcements, personal orders? Chairman Russell, you recognize?
Thanks, Mr. Chairman. I'd like to welcome Steve Crump here. He's a district attorney in my district. Also, the THP that's here. This day in history, 25 years ago, was my first day at the academy. So we'll meet out back and do some push-ups and run a few miles after the committee. So thank you, Mr. Chairman.
Thank you. Anyone else like to be recognized before we get started? Representative Eldridge, you recognize, sir?
Thank you, Mr. Chairman. I have a guest with me today, Luke Geller. Luke, stand up, please, sir. Luke is job shadowing me today. He is in the 5th grade at Cornerstone Academy back in Morristown. And please don't hold this against the young man. He is my cousin, so we're proud to have him with us today.
Leader Lamberth, you recognize, sir?
Thank you, Mr. Chairman. I know we have several of our troopers here today and a couple of the members of law enforcement. If you're one of those folks that serves our community and wears a badge, if you can, just stand up real quick. I want to make you feel welcome and just thank you publicly for all that you do to keep us safe. Thank y'all.
Anyone else before we begin? Anyone else? Representative Beck, you recognize, sir?
Thank you, Mr. Chairman. I just wanted to recognize one of my constituents, David Griswold, who's the head of the chief of police of our airport and does a great job, and we appreciate you, Dave.
Anyone else? We ready to begin? All right. We have a calendar today, and there's a couple bills that's going to be rolled. I'm going to go ahead and make those announcements. That's item 9, House Bill 337 by Representative Stevens. That's going to be rolled for 1 week. So without objection, House Bill 337 be rolled for 1 week. And also item 12, that's House Bill 1005 by Representative Grills. That bill will also be rolled for 1 week. So without objection, House Bill 1005 will be rolled for 1 week. And that brings us back to the beginning of our calendar. Item 1, House Bill 723 by Chairman Halsey. You got a motion and a second. You recognize, sir.
Thank you, Mr. Chairman, and thank you, committee. Under existing law, it seems like if you read it, that a police officer who retires in good standing and works at an institution of higher learning, a public institution of higher learning, can carry a handgun in that institution if he works full-time. You have several that work part-time, and so this bill just clears that up and says, yes, a retired officer in good standing that works part-time in an institution of higher learning can also carry.
And thank you for that explanation. Members, do we have any questions or comments for Chairman Halsey? Looks like motion's been called on the bill. Got a second. All those in favor of sending House Bill 723 to Education Administration, looks like, say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee. And with all the troopers here today, one of your boys wrote me not having a seat belt here about 3 years ago. I'd like to talk to somebody about
that. All right. Item 2, House Joint Resolution 38 by Representative Reedy. You got a motion second. You're recognized. Looks like there's an amendment here. 3864. Would you like to move that forward?
That is correct, Mr.
You got a
Chairman.
motion
Yes,
second. Does
please.
it rewrite the bill?
It does.
Members, we want to get that in the proper posture before we hear about it? Yeah. Looks like we do. All those in favor of adopting House Amendment 3864 to House Joint Resolution 38, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended. And Ms. Reedy, you're recognized.
Thank you, Mr. Chairman. And I'll read for the record, proposes amending Article 1, Section 26 of the Constitution of Tennessee by removing the provision that the legislature has the power to regulate the wearing of arms with a view to prevent crime, and by clarifying that the citizens of the state have the right to keep bear, and wear arms, which is currently the constitutional carry law of the land, reads the same. Mr. Chairman.
And thank you for that explanation. Members, do we have any questions or comments for Mr. Reedy? It looks like we do. We have Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And Sponsor One, thanks for bringing this. This is definitely something I support strongly, but just for the record, I want to get a couple of things out there.
Yes, sir.
I've had folks that have asked me, well, if this constitutional amendment were to pass, does that mean there's no regulations on firearms whatsoever, and convicted felons, domestic abusers, those that have been mentally committed could carry? So how would this affect any of those restrictions on folks that have, quite frankly, lost their Second Amendment rights due to either actions of their own or just aspects of who they are in the mental health arena that simply make it where they're unsafe to bear arms?
Representative Reedy, you're recognized.
Thank you, Mr. Chairman. And Leader Lambert, I don't think it changes that at all. And what is interesting, of course, Leader Lambert, I've been sitting on this since 2018, the documents where I printed off and I said, there's something with this constitutional amendment. Where did it come from? And in the subcommittee, I went through a lengthy explanation, but I will keep this short. And it was interesting, of course, when we first started off, Tennessee becoming Tennessee, that we borrowed the Constitution from two other states when we were putting the Constitution together for the state of Tennessee. And of course, the constitutions were coming from North Carolina and Pennsylvania. Well, during that time, there were the constitutional amendment changes over the years. But what I want to do is fast forward to 1870. And in 1870, of course, there was a lawsuit pending. And of course, the document that I printed off in 2018 was showing in law colleges in the state of Tennessee that was being taught to constitutional lawyers, saying we hovered real close to being unconstitutional with the way that our Constitution reads at this time. So then it was through a lot of research at the constitutional debate leading up to the 1870 language, it was explained by Delegate John A. Gardner that the purpose was to deal with the wave of post-war crime and banditry. Now, keeping in mind, we're coming out of the Civil War. Due to the lack of law enforcement across Tennessee, citizens could be called together for training equipment inspections that could be required to provide themselves with the necessary equipment, whether that included firearms or not. This would produce direct results in terms of law enforcement on the streets. It was noted by Gardner that his amendment recommendation, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime, was merely clarifying an already existing power of the legislature. So with 51 votes, we could sell the lantern off the top of the Capitol. So it was just clarifying. So at the time, there was a lawsuit, and in 1870, it was Andrews versus the state, talking about, now what was interesting in this lawsuit, they challenged the law of this gentleman going armed with both the Second Amendment to the United States Constitution under the right to bear arms provision. And since the constitutional doctrine at that time held that the Federal Bill of Rights did not apply to the states, which actually changed, and of course the change in 2010 because of the 14th Amendment, if we read the 14th Amendment properly. So once again, Mr. Chairman and committee members, because of the current constitutional carry of Tennessee, I think this aligns with that, and it's a lot of mental digestion, Mr. Leader, as this is what I stumbled upon.
Leader Lambert.
Thank you, Mr. Chairman, and please pass on my compliments to Eddie Weeks. I'm sure some of that information came from him. He does a fantastic job. If you've not visited, the floors above us and some of the historical documents of the legislature, they are there for anyone's perusal. But just to be clear, again, there's nothing in this constitutional amendment that would prohibit regulations on those individuals that have committed felonies, that have been mentally committed, or domestic abusers. I mean, folks of those type that, again, currently under state law are restricted from their Second Amendment rights.
It does not, Mr. Chairman.
Thank you. I appreciate it. Thank you so very much. And thanks for the other information too. That's interesting.
Very good. Members, anyone else? Representative Parkinson, you're recognized.
Thank you, Mr. Chair. And I actually would like to go out of session and ask questions to legal on this one, if that's okay, Mr. Chair.
Excuse me, without any objection, saying no, we're going to go to session, hear from Ms. Sonia. Thank you. My mic was off.
Fire away. Okay, thank you. Thank you, Mr. Chair. And my question, I got a couple of questions, actually. And I'm looking at the caption on the amendment clarifies that citizens of this state have the right to keep, bear, and wear arms, not just in the use of defense. And so I'm assuming that, and I don't want to assume, maybe you can clarify for me, that simply means that you can carry, or anyone that's a citizen of our state can carry a firearm, because now this is the Constitution. So this is am I correct in saying that the Constitution is our highest law of the land?
Ms. Sonia.
Yes.
Yeah, okay.
Yeah, you're recognized. Go ahead.
Mr. Chair, do I need to be recognized to
You
ask a
don't.
question?
No, you're
Okay.
good. Go ahead.
Thank you. And okay, and with that being said, it says that citizens of this state, and so those that are felons have been ruled infamous and therefore have lost their citizenship. Am I correct?
Yes.
Which would rule felons out of this statement, correct?
That would be for a court to interpret, but yes, felons have lost their citizenship rights.
Okay, thank you. And now with this being the highest law of the land, being that if it's added to the Constitution, how would that gel with the U.S. Constitution?
Under the Supremacy Clause, when they're in direct conflict, the U.S. Constitution would prevail over the state constitution. But the U.S. Constitution, the Second Amendment places restrictions on the government's authority, including the state government's authority, and the state of Tennessee can place further restrictions on our own government authority. So our state constitution could be more restrictive on the government's ability to regulate arms than the federal.
Okay, and with this statement, if it were added to our Constitution, would this be more restrictive or less restrictive than that of the federal government's Second Amendment wording?
I think that's up to a court to interpret.
Okay. And with this, and I'm just trying to, and for the sponsor, I'm just trying to get better understanding of what we're doing too. So with this, should this be added to the to the state constitution, and it being the highest law of the land, how does that affect individuals who post signs in their places of business that no one can wear or bear arms in their places of business?
I think it would be up to a court to determine if deleting the language, the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. A court would have to determine, does that delete the legislature's authority to pass that statute? I can't say for sure.
And this may be my last question. Okay, if this is in the Constitution, doesn't this supersede any other law that we have created in Tennessee Code?
If a court determined that deleting that language deleted the legislature's authority to regulate the wearing of arms with a view to prevent crime, then any statute that regulated the wearing of arms would be unconstitutional. But that would be up to a court's interpretation of the effect of deleting that language.
Okay, thanks. Thank you.
Representative Todd, you're recognized.
Thank you, Mr. Chairman. And just to clarify something that Ms. Sonia just said, when she said that the states could be more restrictive, notice the word she used. We can be more restrictive on our state with the regulations, with the limitations we're placing on our ability to regulate. So the Second Amendment of the U.S. Constitution says that there's a base. You can't infringe. So we can place more restrictions on our government to infringe. We cannot remove infringements. I mean, we cannot, I'm trying to think of the way I had it in my head a few minutes ago, as she was saying that. It was a very good statement, but I wanted to make sure we got the words correct, that we cannot place more restrictions on that right, but we can place restrictions on government to abridge those rights. I think that's probably the better way to state it. And feel free to correct me if I'm wrong, Ms. Ansonia.
Are there any more questions for legal? Seeing none, we are back in session. And we actually have we have any more questions? If not, I have one. Did I see a finger down there or no? Okay. You and I spoke in your office for, I know, a good 30, 45 minutes. And the way that I look at it, regardless of what the constitutions and when he was saying on infringement, this lines up with Heller, correct?
Yes, Vice Chairman, it does.
That's pretty much where I thought that we're going with this, and so Heller is going to be the standard for, regardless of, that's the interpretation of the current Second Amendment and where we are in regards to our current Constitution. Okay, if there's any further questions, seeing none, we're ready to vote on HAR 38 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? No. The ayes have it. Off to calendar and rules. Next on the item is number 3. Item number 3 is House Bill 878 by Representative Fritz. Got a motion and seconds properly before us. We have an amendment, looks like. Is that correct?
Thank you, Mr. Chairman. Yes, there is amendment, but I oppose that amendment, Mr. Chairman.
You what?
I oppose that amendment.
It's an unfriendly amendment. Okay. Well, it's 4491. Is that what we have? Whose amendment is it? Jason Powell's. Okay, gotcha. Okay. Do I have a motion and second on the amendment?
Yeah.
Got a motion and second on the amendment. Representative Powell?
Sure. So it was explained to me, and this came through subcommittee, I know, that one of the key components of this bill, its intent was to work on issues such as elder abuse. And, I realize that's a very important issue, and how people have used marriage as an ability through elder abuse to take advantage. So I wanted to more narrowly make sure that that was addressed. And so my amendment certainly simply says a person shall not be required to solemnize a marriage if the person has an objection to solemnizing the marriage based on suspicion that a party of the marriage is the victim of an offense under title, which then the title and chapter and part pertains to elder abuse. So I think that it's where the amendment more clearly defines what we're trying to do here, and will hopefully stop this problem of elder abuse in marriage in the state of Tennessee.
Very good. And thank you for that explanation. Members, do you have any questions for the sponsor of the amendment? Representative Capley, you're recognized, sir.
Representative Fritz, I want to thank you for bringing this bill before us. Can you explain a little bit for us why you're against this amendment? No. We're on the amendment. I apologize.
Yeah,
I apologize.
Any questions need to be directed to Representative Powell.
I apologize.
And if there's no questions, what we're going to do is we'll take a vote on this, whether or not we want to adopt this amendment. So if there are any other questions or comments for Representative Powell, we can vote on this, whether or not to adopt it. So anybody want to call the question on the amendment?
Question.
Very good. All those members in favor of adopting House Amendment 4491 to House Bill 878, say aye. Aye. Opposed, say no.
No.
Amendment fails. Thank you, sir. Now we're back on the bill, House Bill 878. I believe you're in a proper posture. You've been recognized. You're in front of the committee. You don't have an amendment to run. So is there anything else you'd like to say, sir? I know Representative Capley may have a question for you, so I'll give you an opportunity to do that if you'd like. He doesn't.
Thank you, Mr. Chairman. I appreciate it. I would just reiterate my call for passage of this bill. This bill is a not significant fiscal note. And this bill is clearly a freedom bill. We did get into specific conversations, Mr. Chairman and committee, in the subcommittee, and I appreciate those, appreciate the effort and thought that went into them. But this is indeed a freedom bill. This bill, and I know you all have the language in front of you. I will read it if you don't mind, Mr. Chairman. That it would, Tennessee Code Annotated, Section 363301 is amended by adding the following new subsection. A person shall not be required to solemnize a marriage if the person has an objection to solemnizing the marriage based on the person's conscience or religious beliefs. I would just offer that this is in order with our state constitution, that we do hold high as Tennesseans, as Americans, our rights of conscience. I would hold that this is within the religious freedoms that are enshrined in both our Tennessee and our U.S. constitutions, and offer to you that it infringes on no one's rights. No one party is mentioned in the language of this bill, nor is any party mentioned that would be infringed upon. This is simply a documentation of the rights of every person, and those who take that solemn task of performing a marriage ceremony certainly deserve to have it documented in our laws that they can refuse to perform those ceremonies. And with that, I'll thank you and ask for your passage.
All right, members, here's where we're at. We have two people that did sign up to speak today. And out of respect for them, we can do two things. One, we can go ahead and we can ask Representative Fritz questions now, but I'll guarantee it that you'll have a chance to ask him some questions after testimony. So what do we want to do? We'll go to session and have some testimony, or we want to ask Representative Fritz some questions? Out of session? All right, very good. Without objection, out of session. All right, Mr. Bullard, Greg. Sir, if you would, just find you a seat there. Any six will do. Just be sure your red light's on. Just introduce yourself for the record. You'll have 3 minutes.
So, can you hear me? Okay. Chairman Farmer and members of the committee, I am Greg Bullard. I am a pastor and simple farmer in Tennessee. And I'd never imagined myself being on the state capitol other than with my kids for a field trip at some point. And I appreciate the representatives' concern for religious freedom, but I also have a couple of concerns because what isn't broken doesn't need to be fixed. As a farmer, I know that I don't mend fences that haven't been broken, and I don't try to hatch out eggs that aren't able to hatch out on themselves by themselves because it will cause the chicks to die. As a pastor of a small congregation, when I heard about this bill by one of my political junkie members, I made a phone call to our insurance agent, and I was told that we would have to amend our bylaws and our statement of faith to be able to reflect who we would and would not marry, so that we could be covered efficiently under our insurance policy. He also told me that we would have to add an additional $300 a year in cost for liability for this, that we do not currently have to pay. There are over 11,000 churches in the state of Tennessee. If each one of them had to add that, that's another $3,300,000 minimum that would have to be added. I understand his concern, but it's not broken, and I certainly don't want to add $300 to the insurance company's pocket that doesn't need to be paid. Thank you for consideration.
Very good, and thank you for that. And first on my list, I have Representative Beck. Oh, you were back in session. I'm sorry. Representative Gant.
Thank you, Mr. Chairman. You caught me by surprise when you talked about insurance. Can you specifically go into what they're going to add to your policy?
They said we would have to add another endorsement, a rider. I don't do insurance. I'm sorry. I do pigs. So they said we'd have to have another rider, and it would cost us a minimum of $24 a month based on our size, and it would probably cost right at $300 for a religious freedom exemption just to avoid the liability to cover any court costs that might come up.
So you don't,
Go ahead, you're recognized, sir.
so you don't know specifically what that rider would add
I don't.
to the policy?
I do know that it adds an additional religious freedom rider to it. That we already have one. We use Brotherhood Mutual, and they already have that in their base policy, but it has to add something like another $1 million or $2 million based off of the way that this is written.
Okay, it sounds like an umbrella policy that they're adding, which extends your liability to a whole nother level as far as the limits go. So I think that would be optional. I can't speak for what your agent told you, but I'm an insurance agent, and so you just kind of caught my attention when you were talking about that. And I do a lot of church insurance myself. So anyway, thank you, Mr. Chairman.
Thank you. Members, any more questions for Chairman Grills?
Thank you, Mr. Chairman. Just out of curiosity, what is it you have to change in your bylaws of your church that would grant
have
you
to
the religious freedom that it's enshrined in our Tennessee Constitution under Article 1, Section 3?
Our insurance agent said that we would have to add who we would and would not marry. We have to be very clear about the delineation of who we will and will not marry in our bylaws. So for some, that would be a very simple statement. For others, it might be more complicated, such as we will not marry a person who's been divorced, or we will not marry whatever, correct? And I know the vast majority of churches are like mine. We just have not put those in our bylaws and our policy statements because it's just not something that comes up, because who's going to go to Greenway Independent Premillennial Fundamentalist Baptist Church, where my father-in-law was a deacon, and say, hey, I want you to marry me. And, they've had 3 previous husbands or something. So it's just something that most churches have not had it. But we were told we would have to make sure by our insurance agent and insurance company that we would have to add very clear delineations of who we will and will not marry. And it hadn't been on our radar before now, if that makes sense.
Any follow-up? You recognize.
Thank you, Mr. Chairman. Do you feel like that it should be up to you as the pastor of that church to be able to marry who you would and who you would not?
Absolutely. And we currently have that. But this would add another requirement that our insurance company has said we would have to do.
You good? Any follow-up?
Well, I would just think it's just another layer that's protecting the religious freedoms is what Representative Fritz is trying to do here. It seems like you're already on board with that, but maybe just this bill goes further than you want. Is that fair?
Yes, because it adds costs and it adds other stuff.
What I would argue that it adds more protections.
Thank you. Vice Chair Jernigan, you recognize.
Sorry, thank you. And I think we went over, Chairman, I think we went over this in sub, where right now it's silent in the code. And right now you don't have to marry anybody you don't want to, or officiate a wedding, I should say, that you don't want to do. When you put this into code now, that's where it's now opened up to a lawsuit either way. So it's kind of conversely, I think, Chairman Farmer, we talked about this in the sub, and I can clarify this with legal, but it looks like they're already doing that over there. That it really does go to the statement you're saying, if it's not broke, don't fix it. When you add this, and what Representative Grills does say, yes, it does give you a further layer. It also puts in the code, which allows the court system to be involved, because now it's there and there can be a challenge. And when that happens, you're saying that's when insurance comes in. And of course, if you want to be covered and they will dictate, really, because you could go under a lawsuit if you don't have insurance. So I just want to maybe just clarify to the members that the reason it is the way he's saying is that it now, when you put it into code, you're now involving the judicial system no matter what, and you're just trying to cover your costs. So I understand that and want to make the clarification. Thank you, sir.
Thank you.
Thank you. Members, anyone else? Will we go back in session? All right. Well, excuse me. We do have one more. We have, and thank you, sir, for your testimony and your time. That's all we have for you for now. But next we have Macy Fluharty. Ma'am, just same rules there. Just find you a seat. Make sure your red light's on. Introduce yourself to the committee for the record. And you'll have 3 minutes once you begin.
Oh, okay. Okay. I'm Macy Fluharty. I'm a resident in Davidson County. In 2015, the Supreme Court recognized marriage to be a fundamental right. LGBTQ plus couples were finally validated and allowed to celebrate our love to the fullest extent. Since this decision was made by our highest court, I wonder if the courts in this subsect began to frenzy. Only a few years after Obergefell versus Hodges, Tennessee made it so an ordained minister via the internet could not legally bind a marriage, which sparked outside legal action. This made it even more difficult for couples to find an officiant to legalize their marriage, largely due to religious prejudice. And now, a handful of years later, LGBTQ plus love is being targeted again under the guise of protecting the elderly. While this is a serious issue, it is an insult that a speaker would deflect from the obvious nature of this bill, especially considering the many bills flying through these halls. I'm a pansexual woman, meaning my love is not bound by sex or gender. I moved here from a very small town and didn't think in a city where I saw my LGBTQ plus friends thrive, my right to love would be threatened, that my friends' rights to exist would be hindered. A marriage not only solidifies a love, it also ensures the safety of one's spouse. Health coverage can change, tax benefits can change. These things can help us grow and thrive and give back to our community. Like my friends have done for you, and now they're moving because they fear you and do not want to support the volunteer state. But to put those life-changing benefits aside, marriage is a tradition recognized in almost every culture around the world. We deserve to cherish it with the same ease that heterosexual couples do. If these bills are to drive us out, it won't work. There is a reason why we say love wins, and that is because hate fails, and pushing these unjust laws in the land of expression will fail. Please vote no on this bill and start focusing on the real issues hurting this state. Thank you.
And thank you for that. Members, any questions for our speaker? All right, seeing none. Thank you for being here.
Thank you.
All right, and that's all I have on the list. So without objection, members, we're going to go back in session. And we're back on the bill, House Bill 878. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And based on the testimony we've heard today and just talking with legal for a moment, under the current code, my interpretation has always been no one's required to solemnize a marriage. Okay, there are lots of folks that have the authority to do so. But if someone comes in and they ask you to solemnize a marriage and they're just grumpy to you that day, or y'all don't get along, you don't like each other personally, or just you don't have time that day, you're not required to solemnize a marriage. The state is required to record a marriage, obviously, but no one's required to solemnize a marriage. So I honestly feel like there's a few too many words in the bill that we have before us. And so, Mr. Chairman, at this time, though I know this is not the normal protocol, but we're not adding to the bill. We're merely just striking words from it. So, Mr. Chairman, with your permission, I would like to make an amendment at this time that we amend this bill to put a period after the word marriage. So subsection M would read, a person shall not be required to solemnize a marriage, period, and strike the remaining portion of the sentence. Thank you. And Mr. Chairman, the words that would be struck would be if the person has an objection to solemnizing the marriage based on the person's conscience or religious beliefs. Those words would be struck, and it would just be a period after marriage. And then look, nobody's required to solemnize a marriage for any reason. It's just there's lots of folks that can do that, but nobody's required to.
Very good. Proper motion. It's been motioned and seconded, and we have that would be, let me just get this procedurally in the right posture. That would be oral amendment 1. We'd be looking to adopt to House Bill 878.
The point of order, if I could get the sponsor to phrase that again, just what the current wording would be of this amendment.
Leader Lambert?
Sir, and so the bill literally would read, Section 1, Tennessee Code annotated Section 36-3-301, comma, is amended by adding the following as a new subsection. M, a person shall not be required to solemnize a marriage, period. That would be the bill before us if this amendment is adopted.
Representative Powell, did that answer your question? Okay. Members, does anyone else have any questions for Leader Lambert before we vote? All right, Representative Harris, do you have a question?
Thank you, Chairman. And so if we were to make this this change in this for this bill, would that suffice to be able to defend it in the case that it goes to court, similar to what happened in Kentucky, where Judge Banning ruled against it? Would that then be able to defend this legislation?
Leader Lambert, you're recognized.
Yes, absolutely. I mean, again, we are not talking about recording a marriage between two people. We are talking about the requirement of someone to solemnize that marriage. That can be done by a long list of people in the statute, and it in no way intrudes on anybody's right or desire to be wed. It is merely a fact of, if you're walking down the street and someone were to come to you and say, hey, you're a state rep, I need you to solemnize my marriage. And you said, hey, look, I'm sorry, literally, I'm going somewhere. You can't be required to solemnize that marriage. You can just say, look, I'm sorry, I'm busy today, can't do it. There's not a requirement to solemnize a marriage by anybody. Anyway, I would argue that that is true under the current statute right now, but this will make it crystal clear. No one for any reason is required to solemnize a marriage, period.
Representative Harris, answer your question. All right. Members, any more questions or comments for Leader Lambert with regards to Oral Amendment 1? Representative Parkinson, you're recognized.
Thank you, Mr. Speaker, and thank you, Chairman. Thank you, Leader, for your comments. I think you may have already answered it. So right now, currently, is anyone required to solemnize a marriage?
Leader Lambert,
And maybe that's a question for legal, maybe.
It would be my interpretation that no one is required to solemnize a marriage. This would make it clear in the statute. I mean, this will lay it out in clear black and white English right there on the page that no one is required to solemnize a marriage. So, I mean, the interpretation, I think, would be that no one is required now, but this will make it very clear.
Very good. And I believe, Representative Parkinson, did you want to go to session just for a moment to hear from Ms.
Just for
Ansonia?
a second opinion.
Okay, members, any objection? All right, out of session. Ms. Ansonia, you recognize.
There's no statute that requires anyone to solemnize a marriage. So there's currently no duty for anyone.
Very good. Representative Parkinson?
Satisfies me. Thank you.
Anybody else? All right. Without objection, we'll go back in session. Anyone else? Okay. Question's been called on the amendment. Any objection? Seeing none, looks like we're ready to vote on Committee Oral Amendment 1 by Leader Lambert to adopt to House Bill 878. All those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Now, the amendment has been adopted, so we're back on the bill as amended, and you're recognized, sir.
Thank you, Mr. Chairman, and thank you, committee, for your patience. I appreciate you working through that so much. I would offer this just simply in my closing remarks. I appreciate the folks that have testified in opposition to this today. I appreciate your engagement. Thank you so much. I do think that the pastor made the argument for why we need this. Because if his insurance company is suggesting that he's going to be sued or at a greater liability if he declines to do a ceremony for someone, I think that fully supports our case for making sure this is codified in the great state of Tennessee. And with that, I'll take any other questions.
Very good. Question's been called. Do I see any objection? Representative Parkinson, are you? Okay, very good. All right, members, ready to vote? Seeing no objection, let's ready to vote to whether or not to send House Bill 878 to calendar and rules as amended. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. Thank you. That brings us to item 4. Representative Fritz, you're there as well. House Bill 1189. And looks like Amendment 4089. Is that something you want to move forward with? Does that amendment make the bill?
Amendment 4089 does make the bill, Mr. Chairman.
All right, members, we're ready to vote and get this thing in a proper form, adopting House Amendment 4089. All in favor, say aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman. Thank you, committee. Again, I would offer this as another support of freedom bill that I offer to you today. I appreciate your consideration on this bill and the amendment that makes it brings exceptions listed in the bill more in line with those of the Federal Protection of Lawful Commerce in Arms Act. The exceptions included in the bill preserve the ability of our citizens to file legitimate claims against bad actors in those industries. Providing firearms, ammunition manufacturers, dealers, sellers protection from civil liability is an important thing for not only our Second Amendment rights in this great state of Tennessee. If we cannot manufacture firearms parts, and ammunition, we do not have a Second Amendment that we can guarantee our right to keep and bear. It is also a financial incentive for this state, I will offer to you. We have seen examples in the United States where the federal law has not been sufficient to prevent a lawsuit that has been devastating to manufacturers. I think this vote of support by this body will indicate to our firearms manufacturers in the state that we are fully behind that industry. As of September 2021, Tennessee is #1 for employment in this industry, according to the Tennessee Department of Economic Development. There are 20 firearms and ammunition manufacturers in the state. They include the new ones, Smith & Wesson, Beretta, GS Performance, and parts and accessory manufacturer for Glock. These companies have moved here and made large capital investments in our state. Our employees, our Tennesseans that work at these facilities depend upon this industry. Passing this legislation will not only protect these companies, but will also protect our Tennesseans that work for those companies. We do have some room to grow in our firearms manufacturing when compared in the Southeast, which is considered the competitive market for this manufacturer. We rank between 2nd and 7th in how many firearms we produce. I would like to see those numbers go up. Those numbers going up, which may be a result of this bill, will mean more jobs, more quality jobs for Tennesseans. So I would ask you to certainly support this bill, and I'll pause, Mr. Chairman, take any questions y'all may have.
Very good. Thank you for that. Members, any questions or comments for Representative Fritz? Seeing none, let's ready to vote to send House Bill 1189 to calendar and rules as amended. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thanks so much, Chairman and Committee.
Thank you. Brings item 5, House Bill 578 by Representative Bricken.
Thank you, Mr.
Looks like you got an amendment as well, 4022. Is that something you want to move forward with?
That amendment was added in sub, and it does make the bill, sir.
Very good, members. We want to vote to adopt House Amendment 4022. Got a motion, got a second. Looks like we do. All those in favor say aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, and you're recognized, sir.
Again, thank you, Mr. Chairman. House Bill 575, I consider is a public safety bill. The bill, as amended, simply removes the $100 application and processing fee for the enhanced handgun carry permit. By removing this fee, we'll be encouraging our citizens to take the department's approved handgun safety course. It will promote public safety as more citizens hopefully will get properly trained in the use of a handgun. The bill is got a sunset provision of 3 years. With that, I'll certainly entertain any questions.
And thank you for that explanation. Members, who have any questions for Representative Bricken before we vote? Doesn't look like it. So without objection, we'll be voting to send House Bill 578 as amended to finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you.
That brings us now to Chairman Russell, House Bill 1120. Looks like we have an amendment 4147. Does that amendment rewrite and make the bill?
That's what I showed, Mr. Chairman.
Very good.
Yes.
Members, we want to vote to adopt this amendment. Got a motion, second. Looks like we do. So all those in favor of House Amendment 4147 to be adopted, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended. You're recognized, sir.
Thank you, Mr. Chairman and committee. House Bill 1120 came out of the Ad Hoc Committee for Juvenile Justice. It requires the department to provide annual training to youth service officers on the best practices for behavior management and conflict resolution in the context of supervision of juvenile justice youth. Requires the department to make chaplain services available on a regular basis to juveniles who are in the department's custody and housed in the juvenile detention facility, approved, certified, or licensed by the department, including youth development centers, prohibits the department from requiring a juvenile to attend or make use of chaplain services. It requires juveniles 16 years of age or older in the Department of Children's custody in a level 3 or 4 facility to be housed, educated, and maintained separately from the children unless that clause violates state law. Mr. Chairman, I renew my motion.
Very good. And thank you for that explanation. Members, do we have any questions or comments for Chairman Russell? Doesn't look like we do. Looks like we're ready to vote to send House Bill 1120 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. Representative Powell, item 7, House Bill 1080.
Thank
And you got a motion and a second. You're properly recognized.
Thank you, Mr. Chairman, committee. This bill simply makes it explicit that charitable organizations, including churches, can open up their doors in the event of a severe weather event for a place of refuge for people. It currently is implied, but this just makes it explicit. Several different states have passed safer places laws, such as Alabama, that are constantly under severe attack of severe weather events. And so wanted to address a leader's question last week, but this legislation does keep in place present law that would hold an organization liable if such an organization actions constituted gross negligence or acts willfully or with wanton misconduct. It just makes it explicit in the code that these organizations can open up their doors during severe weather events.
Very good. Members, any questions or comments for Representative Powell? Chairman Todd, you recognize.
In the explanation that we have before us of the bill, it already says that present law defines services as providing food, housing, or shelter from adverse weather. This sounds like it's duplicative, and I don't see a reason for this.
Is that a question for the sponsor or just a statement? Okay. Members, any more comments or questions before we vote? Representative Parkinson, you recognize. You recognize.
And I was Chairman Todd. I was the one that I probably shouldn't have called your name, but I accidentally did. Right. I was the one that passed that initial bill. But I think what this bill does that Representative Powell is bringing is adds, I think, what is important language, especially given the disasters that we've had in throughout our states, that is not just for housing, but also for those terrible weather events that we have. And I don't think it's harmful to what we passed, and I think you were part of it also, to what we passed that was 2 years ago, to open up for the housing parts. Thank you, Mr. Chair.
And thank you for that. I have a couple more people on the list. I have Vice Chair Jernigan, then I'll get to
his name.
Representative Powell and Chairman Todd.
Well, Todd's name was called.
I'll yield to Chairman
Very good.
Todd.
Chairman Todd, you recognize, sir.
Well, I appreciate that. And again, it already says shelter from adverse weather, and I don't see any reason for this. I guess, has there been a situation, and I'll ask this to the sponsor, that where this has come into play, where someone has been sued or had some liability related to this?
It has in the past, and where the genesis of the bill is 2 different places. One, I had a couple different meteorologists reach out to me who said that they have had issues where churches were not aware they could open up. And so I think this will provide hopefully greater awareness and be very explicit that these places can provide places of refuge. I've also had people in my community say, they weren't very clear. I'm not trying to be duplicative, and I appreciate this is simply trying to make it explicit to hopefully continue to get the word out when there's severe weather events that people have a safe place to go.
Chairman Todd, any follow-up, sir? All right. I had you on the list next. Representative Powell, you're good. And Chairman Todd, you've been spoken for there. Members, anybody else before we vote? All right. Seeing that's like ready to vote whether or not to send House Bill 1080 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. That brings us to item 8, House Bill 395 by Representative Capley.
Thank you, Mr. Chairman.
And you got a motion and a second. That doesn't look like you have an amendment, so you're probably recognized.
Yes, sir. Thank you. This bill was brought to me by TWRA. As many of you know, I am a sportsman myself, so House Bill 395 would bring together several sections of Title 70 regarding wildlife resources in line with the permitless carry changes made by the General Assembly. The statutes their effect would have either flat prohibitions or prohibitions subject to a handgun permit that would no longer conform to the general state of handgun carrying in the state. So, for example, members, if you'll allow me, if someone is bow hunting in the state of Tennessee and they have a sidearm on them, and as long as they're not using that sidearm to in the advancement of taking game, then this would eliminate the restriction based on the permitless carry statutes that have been passed by the General Assembly.
Very good. I appreciate that explanation. Members, have any questions or comments for Representative Capley, Representative Parkins?
Thank you, Mr. Chair, and thank you, Representative, because you've been educating me in this area. And I said you have to be a pretty talented person to be shooting a bow and carrying a firearm at the same, or shooting a handgun at the same time. My question is, and this is simply based on cultural differences, because then I don't know why can you not hunt with a handgun?
Representative Capley, you're more than welcome to answer that.
I think we have some friends from the TWRA here that would be willing to answer that question, because I'm sure my answer, being from Southern Middle Tennessee, would probably not align with theirs.
Got you.
I honestly just wanted to know the answer. We don't have to go out of session.
Okay. Well, I bet you. We'll just ask for somebody to get from the TWRA to get you that answer.
Okay, thank you. I'll take that. Thank you.
Does that
Thank
sound
you.
good?
Thank you, Mr. Chair.
We actually have Daniel Cox on the list, and without objection, we'll go to session. We'll find out real quick. Any objection? No? All right. Let's find out. It shouldn't take just a moment here. Mr. Cox, you would just make sure your red light's on, introduce yourself, and if you could tell us why, or what, I guess Mr. Parkinson probably could ask the question again. Yes.
So I was trying to figure out why you can't hunt with a handgun, because I simply don't know.
Yeah, thank you, Chairman Committee. There's actually no immediate prohibition on hunting with a handgun. There's only a prohibition on the size of caliber that you use. And the only reason for that is to make sure that the caliber you're using is effective for the size of game. But there's no immediate prohibition on using a handgun.
There you
go. Okay. Thank you. Thank you, Mr. Chair. Thank you for that. Appreciate
it. Have any other questions for Mr. Cox while we have him up there? All right. Thank you so much. All right. Without objection, we'll go back in session. All right, we're back on the bill. Any more questions for Representative Capley? Are we ready to vote? Looks like we are. We're voting to send House Bill 395 to calendar and rules. All in favor say aye. Aye. Opposed say no. Ayes have it.
Thank you, Mr. Chairman and committee.
That brings us down to item 10, House Joint Resolution 80 by Chairman Todd.
Second.
And you're probably recognized, sir.
Thank you, Mr. Chairman. We are extremely fortunate in this state to have an attorney general that has demonstrated a very strong stance by defending the U.S. and Tennessee constitutions, by defending our state's rights and protecting our freedoms enjoyed by our citizens. This in no way implies any concern at all with our attorney general and the exceptional job he's doing for this great state. It simply urges the attorney general and reporter to evaluate any newly passed federal statute, regulation, or executive order that may affect the rights of Tennesseans to bear arms, and if such statute, regulation, or executive order infringes on that right, to bring suit on behalf of the state of Tennessee to challenge any such infringement. I want it on the record for all to see that this General Assembly supports our Attorney General in his efforts to protect our rights. With that, Mr. Chairman, I will take questions.
And thank you for that explanation. Members, does anyone have any questions or comments for Chairman Todd? Seeing none, are we ready to vote? Seeing no objection, we're going to vote to send House Joint Resolution 80 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. The bill moves on. That brings us to item 11, House Bill 1006, Chairman Grills. No amendment. Got a motion and a second. And you're recognized on that bill, sir.
Thank you, Mr. Chairman. This bill simply removes the $350 civil asset forfeiture bond in order to have an administrative hearing.
Very good. Question's been called. Any objection? Seeing none, let's we're ready to vote. Send House Bill 1006 to finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. That brings us down to item 13, House Bill 239 by Representative Bolzo. Second. Got a motion second, sir. I'm not seeing any amendment, so you're properly recognized.
Thank you, Mr. Chairman. Members of the committee, this is a bill that seeks to provide a definition for the term sex as used in the Tennessee Code. The term actually appears a total of 275 times throughout Titles 2 through 71 of our code and in some of our rules that govern proceedings in court. The proposed legislation would simply provide a definition for the word sex that would refer to one's immutable biological sex as determined by anatomy and genetics at the time of birth and as evidenced by one's original birth certificate. We respectfully move passage, Mr. Chairman. Thank you.
Folks, just give me one moment. All right, folks, I apologize about that. I just want to be sure we were in the proper posture here. Thank you for the explanation. I've got three people who's asked and gave the office notice to testify on this bill, and I do want to give them the opportunity to do so. So members, if with not seeing any objection, could we go out of session here from these folks? Okay, without objection. And I have, first on the list, I have Larissa Romero. Larissa, if you would, just find a seat there, ma'am. Make sure your red light's on and microphone's directed properly, and introduce yourself, and you have 3 minutes.
There we go. Good morning, or good afternoon at this point. Good afternoon, Chairman Farmer and members of the Civil Justice Committee. Thank you for your time. My name is the Reverend Larissa Romero, and I live in Brentwood, Tennessee. And I am here in the name of the God of expansive and inclusive love, Jesus Christ. And I oppose House Bill 239, defining sex as a person's immutable biological sex determined at birth. I have seen the hurt and fear this kind of erasure causes in the Christian church, and it saddens me to imagine that hurt writ large across the state were it written into law. We, each of us, hold identities that change over time. None of us are immutable. And I know from walking with God's children in the church that when we say we must be immutable, it creates a sense that our true and vulnerable selves in all of our changes cannot be valued or held with dignity or worthy of love. I've seen this harmful interpretation drive folks out of the place where they are supposed to come and know they inherently belong in all of who they are and in all of the ways that they are becoming. And in the last few weeks alone, I have cried with and held the trembling hands of God's precious ones who are afraid and feel as though their state is making efforts to drive them out of their home. I've seen too the beauty and joy of beloved folk who know that they are not just accepted, but celebrated in all of their discovery and longing to be in the world as it becomes clear to them that this is who they are. And finally, I have a 2-year-old daughter, and I don't know the whole of who she will become. And I'm afraid to raise her in a state where if she tells me, Mama, actually, I feel a disconnect between what the world tells me I am and who I know myself to be, that I won't be able to have this long process of accompanying and caring for her through that self-discovery here. And so I urge you to vote against HB 239. And thank you for your time and consideration.
All right, and thank you, Ms. Romero. We appreciate that testimony. Members, do we have any questions for our guest? Okay, thank you so much. Thank you. All right, next let's have River Allen. Miss Allen, if you would just sit down and introduce yourself. Be sure your red light's on. You have 3 minutes, ma'am.
Okay.
Hi, my name is River Allen, and I live in DeKalb County, Tennessee. For the past 5 years, I've been a at-home health caregiver for a trans elder who is bedridden. I'm here to speak against HB 239, which seeks to remove transgender individuals from the law entirely. And revoke their right to change any identity documents, including driver's licenses. If I run out of time, someone please ask me about my friend Josephine and ask me about the parents in my county. I want to read excerpts from an article by an amazing reporter, Erin Reed. The article is called "We Must Ban Transgenderism Entirely. Republican Operatives Increasingly Say the Quiet Part Out Loud." She says, while the idea of eliminating transgender people was once only heard in obscure far-right podcasts from pastors such as Mark Burns, rhetoric advocating for the wholesale destruction of transgenderism, and thus transgender people, is now espoused by some of the leading figures in the Republican Party. Matt Walsh has declared war on the transgender community, while Candace Owens has referred to trans people as demonic and expressed a desire to, quote, beat them with a cane. Charlie Kirk has suggested that transgender people should be, quote, dealt with by men like in the 50s and 60s. Just yesterday, Michael Knowles called for a complete ban on transgenderism, arguing that transgender people are not a legitimate category of being and therefore cannot be the target of genocide. These are not insignificant people in the Republican Party. Matt Walsh was behind the very first gender-affirming care ban introduced this year. In 2022, Matt Walsh met with Representative Lamberth, author of the Tennessee Gender-Affirming Care Ban HB1. Michael Knowles works at the Daily Wire, which has an annual revenue of over $100 million, and its reach within the Republican Party is extensive. In Matt Walsh's message to the trans community and drag artists, he says, "We aren't even remotely done. This is honestly only the beginning. We've got a lot more in store for you. I promised you a year ago that we were going to war. There is much more to be done, and it needs to be done, and we aim to do it." Given that we have over 400 anti-trans bills moving through the country that are targeting adults, withdrawing people from medical care, charging trans people with sex crimes just for being in bathrooms, Texas agents investigating people for child abuse and threatening to take children, making dressing and drag illegal.
Thank you. Thank you. 3 minutes up. Your 3 minutes is up. Thank you so much. All right. We'll ask the questions. Thank you. All right. Members, do you have any questions for our guest? Leader Lamberth.
Maybe you don't have to yell. It's okay. The time was out, but I'd be happy to hear what else you wanted to share. So it's not necessary. I know you said you wanted one of us to ask questions so that you could continue. If you'd like to, I'd be more than happy to hear what you have to say.
And Miss Allen, you're recognized. You'll have to push that red button again. Your time ran out.
Thank you. I would love to talk about the financial impact statement of this bill, and that relates to the parents in my county. So basically, the fiscal note of this bill reads that the Department of Education statutes that the provisions of the legislation could create legal risk and jeopardize federal funding award programs for programs such as Title I, Perkin, IDEA, and other awards of an estimated basically $1.3 billion in fiscal year 23-24. And so I want to know if all of your constituencies support House Speaker Cameron Sexton's call to reject all federal dollars to the Department of Education so that children can be educated the Tennessee way. Because this is indirectly what this bill does. Are you truly planning to break these anti-discrimination mandates and block all of your constituents from $1.3 billion that the Department of Education needs? The majority of these federal education dollars are directed to schools that serve low-income students, students with disabilities, and rural schools. So first, you should talk to the teachers and the parents in my rural county, where 3 out of 5 elementary schools were shut down last year because of underfunding. And now parents have to drive up to an hour to pick up their kids. So ask them how much they care about trans people simply existing. Also, HB 239's fiscal note specifies that according to the Department of Health, federal grants specify an alternate definition of sex. The Department of Health receives over $750 million in federal grant funding. This funding may be withheld if the state is found out of compliance with federal requirements, end quote. That was from the fiscal note. Tennessee ranks in the top 6 worst states for both health outcomes and premature deaths. Taking away $750 million from the health budget is not in the material interest of your constituents, even if they are not trans. Also, there will be an increase in state expenditures because of a bunch of court fees, right? Because you have to give full faith and credit to the public acts of every other state. So if this law passes, it will likely be ruled illegal to refuse to recognize trans people's birth certificates from other states. This bill codifies sex in a way that legally defines about 30,000 transgender people and about 11,000 intersex people out of existence. It isn't a matter of simply defining. This has material impacts on thousands of people.
Thank you for that. Leader Lambert, do you have any follow-up? Okay. Members, any other questions for our guests?
Josephine.
Excuse me, Vice Chair Jernigan, did you want to be recognized, sir?
I would like to hear about your friend Josephine. Go right ahead.
Thank you.
And Ms. Allen, you're recognized.
Thank you. So my friend Josephine says, as a trans woman, I changed my marker on my Tennessee driver's license in 2018 to female. Prior to this, when out of state in a routine traffic violation, my ID gender marker was incongruent with my gender expression and my visible breast tissue. I was frisked on the interstate. This involved forcibly being jabbed in my breast tissue and a full body search, only because of the incongruence of my ID's gender marker and my physical body. None of this has ever happened in Tennessee when my taillight has been out or I've been pulled over. And I know that my sex marker on my license protects me. This will be gone with this bill, and my body will likely be violated and violently searched if detained, because my gender expression will again be incongruent with my ID's gender marker and my transgender reality.
And thank you for that. Any follow-up there, Vice Chair? Seeing none. All right, and thank you so much. All right, now we have one more on the list. We have Darren Johnson. If you would, ma'am, just go ahead and have a seat there. And you may have testified in front of the committee before, so you probably know the drill, but if you would, just please introduce yourself. Be sure your red light's on. You'll have 3 minutes.
Thank you. Chairman Farmer, Vice Chair Jernigan, members of the committee, thank you for allowing me time to offer perspective on HB 239. I am Chaplain Darren Johnson, a 19-year resident of Davidson County. As I wrestled with how to prepare this testimony, I found myself stuck for days, pinned down by the magnitude of all this bill carries. For let's not dance around the issue. To the previous testifier's point, this bill seeks to implement a change affecting the whole of the Tennessee Code. While it's been referenced in other settings as simply a minor corrective, what this bill seeks to do in actuality is to center a definition of sex used in laws being adjudicated still at this very moment, takes that language, moves it upstream so that its contested understanding can hold definitional sway. To enact this bill's strict binary understanding of sex is to sentence us, to sentence me to purgatory throughout state law, especially since there is no definition of transgender persons or other formal statement of our status or even mention of us in the Tennessee Code. While it's touted as a way to provide clarity, this bill foments only uncertainty and fear. Such an ongoing crisis of existence is quite frankly overwhelming, with one question only opening the door for the next concern. For example, should this law pass, what would become of my Tennessee driver's license? You know, the one that is marked female. Would that be subject to new inquiry? What would be the new test? Now, this bill does list its standard as the sex listed on the person's original birth certificate. How, though, does the state come by that? I've never even seen my original birth certificate, having been adopted and with the original one sealed. And it's from out of state. What would Tennessee, in all of its clarifying zeal, do then? It is here that the bills note that it is not limited to just this test becomes especially worrisome. What other means is the bill leaving open for the state to take? Physical checks, separate but equal IDs? In what circumstances will I be forced to learn just how contingent my existence is in the eyes of the law and some others in this state? All this and this bill still claims it exists because the public welfare requires it. However, to that point, I'll grant there's one thing this bill does clarify successfully, that whatever is meant by that term, whoever the public is and whatever their welfare, I and the whole of the transgender and gender expansive community are certainly not included.
All right,
I
thank
urge you to vote no on this bill. Thank you.
Thank you. Appreciate that testimony. Members, do we have any questions for our guest? Any comments or questions before we go back in session? Thank you so much. Seeing none. So without objection, we're going to go back in session. We're on House Bill 239. Any questions for our sponsor? Any comments for our sponsor? Chairman Grills, you recognize? I'm sorry, Representative Harris. Okay. Chairman Grills.
Thank you, Mr. Chairman. And we sat here and we heard the testimony, and the one witness said that they represented the Lord and Savior. And I just wanted to reference what his word said, because it was somewhat offensive for her to put words in his mouth. In Genesis chapter 1, verse 27, it says, "So God created man in his own image. In the image of God created he him. Male and female created he them." And once we have these discussions, it seems, once again, we talked about it last week, that we have an attack, a full frontal attack on the very nature of God. God created man. He created woman. He put them in this world to procreate and to replenish the world. And when we continue to spit in the face of God as a nation, we're going in the wrong direction. I want the blessings of God, not the curse of him. Thank you, Mr. Chairman.
Thank you for that. Representative Harris, you recognize, sir.
Okay, Chairman, thank you. So exactly, sponsor, what problem will this bill resolve?
Representative Bozo, you're recognized in response.
Thank you, Mr. Chairman. Representative Harris, I think it resolves disputes similar to those that you've just heard for the past 15 minutes. Science is clear. Biology is clear. Genetics is clear. Every cell of the human body has 46 chromosomes, 2 sets of 23 pairs, the first 22 of which are known as autosomes, the 23rd of which is known as the sex chromosome. If you have 2 X chromosomes, you're female. If you have an X and a Y, then you're male. For all of human history, this has never been in dispute. And so what this bill does is it does something procedural and it does something substantive, both of which are clarifying in the law. First, procedurally, it establishes that when this General Assembly, from the time of the formation of the state of Tennessee in 1796 to the present, has used the term sex, the body has intended to refer to male or female, man or woman, boy or girl. Is there any doubt in the mind of anyone, any member of this committee, or in fact, in the mind of anyone who can hear my voice, that whenever this General Assembly has previously used the term sex, it has referred to man or woman, boy or girl, male or female? I think the answer is obvious. So the first thing that we're doing procedurally is clarifying that whenever this body has previously used the term sex, it's been in reference to what Representative Grills just referred to, male or female, man or woman, boy or girl. And then substantively, it does set down a marker. You've heard testimony this afternoon about there's no definition of transgenderism or what a transgender person is. And the reason is that we have only two kinds of people in the world. We've got men and we've got women. We have males and we have female. We have only two types of children in school. We have boys and we have girls. And there are those who tell a boy who wants to be a girl that that's normal. Well, that's not normal. That's abnormal. And you do tremendous violence to a child when you take a child who, for some reason, has been confused about what sex the child is and tell the child it's normal to want to be the other sex. That's the opposite of normal. And what this bill does is lays down on a marker that in the state of Tennessee, we are going to go in accordance with science, biology, genetics, and we're going to call males male and we're going to call females female. That's the need for the bill, Representative Harris.
And thank you for that. Any follow-up, Representative Harris? You recognize.
Thank you, Chairman. And so looking at this fiscal note on here, how are we going to address making sure that these departments don't lose their federal funding?
Representative Bozo.
Thank you, Mr. Chairman, and thank you, Representative Harris. In my view, this body should do what's right, morally and ethically, regardless of the cost. I don't care what it costs, Mr. Harris, Representative Harris, to do what's right.
Representative Harris, any follow-up?
Last one is with this word being defined as far as sex, and this may be a question for legal, but how does that affect other words within our law, like sex abuse, sex trafficking?
Representative Bozo.
Thank you, Mr. Chairman, and thank you again, Representative Harris. That's an excellent question. And there's obviously a companion bill traveling in the Senate, and the Senate version of this bill is going to include a clause to address that concern, because you are correct. In the code, we do have words like sex crime, sex offender, where the context doesn't mean a biological male or a biological female. So the Senate bill is going to include a clause that says, quote, unless the context indicates otherwise, comma. And when this reaches the floor of the House, if it does, I'll make a motion formally to conform the House version of the bill to the Senate version of the bill to address that very point.
Representative Harris.
Can I then make a motion to roll this a week so that way the Senate can pass theirs first, so that way we have it in full form before we take it to the floor?
You can make a motion. You got a motion, got a second. Any objection, Chairman Todd?
I don't think procedurally that's even necessary, because we quite often, when the Senate is ahead of us, we conform to the Senate bill. We adopt the Senate bill and run that on the House floor and vice versa. So I think this is not needed whatsoever.
Okay. Representative Powell, you recognize.
If I could, Mr. Chairman, I mean, I've only been serving this body for 10 years, but I have never heard someone on a committee say that they were going to, when a bill is in the committee, the whole point of the committee system is to get bills in the posture we want before they advance out of a committee. And this is the first time I've ever heard a member say that they were going to not conform to the posture the bill is in the committee and move to the Senate bill. So I would feel more comfortable keeping this bill here out of respect for the committee process. And if he wants to amend the bill, that's fine. But I think if the intent is to change the bill, we should keep this bill in this committee until it's in the posture and the form the sponsor wants it to eventually be in.
And thank you, Representative Powell. I'm at the will of the committee. There's been a motion properly seconded, so let's vote on it. So all those in favor to roll this bill 1 week, say aye.
Aye.
All those opposed, say no. No. Noes have it. Bill stays here. And it brings us back to, where we at? I think we're, okay, Representative Powell, you're on the list. There you are. You're recognized.
If I could, just a statement. I want to say to the sponsor, I am in earshot. I am on this committee, and I disagree. I want to be on record for letting that be known. I'll also be voting no, but I also want to be known that I'm in earshot on the committee, and I disagree with some of the statements that were made.
Okay. And thank you for that. Members, we ready to vote? Looks like we're ready to vote to send House Bill without objection, send House Bill 239 to Finance. All those in favor say aye.
Aye.
All those opposed say no.
No.
Well, the ayes has it. Bill moves on. If you want to be recorded as a no, just let the clerk know. That brings us to item 14, and that's my bill. If I could get Vice Chair Jernigan, do that. And I have an amendment, members, 4503.
Question on the amendment.
Man, do I get to talk at all?
Question on the amendment.
All right, so we're at House Bill 1367. It does have an amendment 4503. Is that correct?
That's correct.
All right, we have a motion and a second and a question on the amendment. So 4503 is what I have. Is it 30?
I think it's 4503. That's
Okay,
what I, hold on,
03.
wait.
All right.
Yeah, 4503. That's what it's marked.
Thank you, Chairman Ty. Okay, the question been called the amendment. All those in favor of the amendment say aye.
Aye.
Those opposed, ayes have it. And so we're now on the bill as amended.
Right.
Chairman Farmer?
And what this does, we passed in 21, we passed the opioid abatement fund, and that allows settlements from these companies that did some harm to our state and our country, to allow for our state to accept monies off those settlements. We have some new settlements coming in. So this would allow for us to accept, I believe, around 400 and, to accept right at $490 million to go into the abatement fund to be dispersed between the state and municipalities. And I move passage.
All right, we have a question on the bill. The objection, we'll be voting on House Bill 1367 to go to finance. All those in favor say aye.
Aye.
Those opposed, ayes have it. You're off to finance, sir.
Very good. And I believe that's all we have for today. And I'm looking at Courtney to be sure. We're in good shape. So I appreciate everyone's time, and we will adjourn a week from today. Thanks so much.